Good day, ma'am. We are the Group 6 and we are here to discuss the principles of law on obligations and contracts. So the essential terms that will be used in these sections are defined below for our collective understanding. First is the active subject. It is also known as the creditor or the obliged. It is a person who has the power to demand and fulfillment of the obligation. Casual fraud o dolo cosante that was committed at the very beginning of the transaction to induce or convince the other person to enter into a contract. Contracts. It is a meeting of the minds whereby one binds himself to others to give something or render some services. Defendant, a person in a law case, who is accused of having done something illegal. Delay. This means that when the maturity date within which to perform the obligations was not fulfilled, the creditor should demand its fulfillment for the debtor to be considered in delay. Delect. It is an act by which one person, by fraud or malignity, causes some damage or tort to some other. Incidental fraud o dolo incidente, a fraud that was committed during the performance of the obligation. Instrument, the paper where the contract was written. Jurisdictional tie, it is vinculum or that which binds the debtor and the creditor. Negligence, it is omission of what diligence required by the nature of an obligation and corresponds to the circumstances of a person, time, and place. Obligation, it is a judicial necessity to give, to do, or not to do. Passive subject is also known as the obligor or the debtor. It is the person who must fulfill the obligation or the presentation. Prestation. It is the object of the obligation either to give or to do or not to do. Quasi-contract. It is an obligation that the law creates in the absence of an agreement between the parties. Last is the quasi-delect. It is an act whereby a person without malice, but by fault, negligence, or imprudence not legally excusable causes injury to another. So the first objective of this week is to understand the basic principles of the law on obligations and contracts and how this law creates a relationship between parties. We will be discussing thoroughly the essential topics that we need to learn in this section. So first is the article 1156. An obligation is a judicial necessity to give, to do, or not to do. The obligation meant here is only those obligations which is not performed by one party. The other party may go to the court to enforce the obligation or simply to hold such person to pay for damages. Hence, not all obligations are enforceable before the courts. For example, it is an obligation of a student to study hard, but supposing he or she does not, the parents cannot sue their child for not studying because that is not a civil obligation. So the civil obligations are those that arise from any of the following sources. First is the law, contracts, quasi-contracts, acts of omissions punishable by the law or the delects, and the quasi-delects. So second is the element of obligation. Passive subject, a debtor or an obligor is responsible for fulfilling the obligation. For example, Mr. Juan applied for a loan in a bank. He is then referred to as a passive subject or the debtor, as he is the one who was an obligation to pay for the loan. So if it goes to Mr. Juan, it is your obligation to uh, pay the loan. Pay the loan. So second is the active subject. A creditor or an obligee has the power to demand the fulfillment of the obligation. In the previous example, it is the bank that has the authority to require Mr. Juan to pay the loan. Hence, the bank is an active subject. So it is sabotable. The prestation is the object of obligation in the example given above. The obligation is to pay the loan, hence, paying the loan is a prestation or um, a benefit of both parties. So the judicial tie is the vinculum of the debtor and creditor. In this case, it is in the form of an agreement or a contract to pay the loan. So, um, naa sila'y kontrata. So third, sources of obligation. First is the law. Obligations arising from law. Examples are paying tax, securing a license to operate a business, registering a corporation to the Securities and Exchange Commission, or supporting by a parent to his child. So for example, is the Lakbay Travel and Tours is earning a lot of income. However, it fails to pay taxes. Can it be sued in the court? Yes, because every taxpayer must pay taxes. This obligation is imposed by the National Internal Revenue Code of the Philippines, which is the law. So, mo nang like murag na stop ang ABCBN kay wala sila nakabayad sa ilahang obligation, which is the ilahang tax. So second is the contracts. Under the Article 1305, a contract is a meeting of minds whereby one binds himself to others to give something or render some services. If a person enters into a contract, an obligation will rise. So for example, in a contract of sale, one of the parties has an obligation to transfer ownership. In a contract of loan, one of the parties has an obligation to pay the indebtedness. In a contract of transportation, the common carrier, which is the public transit, has an obligation to carry passenger or the goods using the utmost diligence. In this case, obligations are not fulfilled, the injured party can sue the other before the court for breach of contract. Next is the quasi-contract. This source of obligation is a retroactive arrangement between two parties who have no previous obligations to one another. It is created by a judge to correct circumstances in which one party acquires something at the expense of the other. So example, person A ordered and paid a pizza from Pizza Hut. However, the delivery man delivered the pizza to person B mistakenly. If person B took the pizza from the delivery man, he is obliged to pay the equivalent amount of pizza. So it will be reimbursed to person A. A court could be ruled in issue a quasi-contract requiring person B to pay for the pizza and reimburse or deliver another set of pizza to person. So this aims for a fair resolution of the situation. So second is the delects or the acts of omission punishable by law. Under the revised Penal Code of the Philippines, any person criminally liable is also civilly liable. The civil liability pertains to the damages that must be paid arising from the offense committed. So for example, Pedro is a security guard in a hotel. He had a heated argument with Juan, who is a hotel guest, and fired a gun to him, which caused the latter's death. So in this case, Pedro will be held criminally liable and be imprisoned. More so, he will be also civilly liable by obliging to pay for the damages suffered by the family of Juan. So such as the funeral expenses, medical expenses, moral damages, and others. So makabayad si Pedro. So quasi-delects or the culpa acliana under the civil code, whoever will cause damage or injury to another due to fault or negligence, there is no pre-existing contractual obligation, shall be liable for the damages. So the requisite of the quasi-dialects, first, there must be negligence on the part of the defendant. Negligence causes damage or injury to another, and there must be no pre-existing contractual obligation between parties. So, if the requisites are present, the person who suffered injury or damage may go to court to file a case for damages based on quasi-delects or the culpa achilleana. So, example, Pedring broke the window of your office while playing baseball. So it would not have happened if Pedring played a little farther from your office. Thus, Pedring should pay for the damages caused by his act to you, even without a pre-existing contract. Kaya nakasala man si Pedring sa bintana, so kinahanglan niya bayaran to. Kay pwede man siya mo dula og baseball sa layo nga dili maigo ang bintana, so ingana. So the owners and managers of an establishment are liable for the negligent actions of their employees based on the quasi-delects. So Article 2180, paragraph 4, the owners and managers of an establishment or enterprises are responsible for damages caused by their employees in the service of the branches in which the employee is employed or on the occasion of their functions. So before the employer may be held liable for the negligence of his employee, the act or omission which caused the damage must have occurred while an employee was in the actual performance of his assigned task or duties. So for example, Tomas is a driver of Viaje Travel and Tours. So one of his functions is to pick up the guests at the airport. So one day, he was tasked to fetch a guest at the airport. But along the way, he accidentally bumped a pedestrian named Juan de la Cruz in the street, which caused his instant death. So can the family of Juan de la Cruz sue the owners and managers of the Viaje Travels and Tours? Yes, because in the case of quasi-delects, the owners and managers of an establishment or enterprise are responsible for the damages caused by their employees. So, however, the owner or manager had shown evidence that it exercises the diligence of a good father of the family in the selection and supervision of its employee, they will not be able held liable for the damages. So, for example, like nahitabo pud ni siya. So like for example, nahitabo po ni siya sa um amua like nabanggaan sa ang sakyanan sa tig-deliver sa kanang gasol. So nakabayad sila ang tag-iya sa gasol. So ang manager sa gasol. So when is an employer or manager not liable for the negligence of its employees? So the owners and managers liability is relieved when it's exercises the diligence of a good father of the family in the selection and supervision of its employees. Once evidence is shown by the employer performed the required amount of care in selecting his employees, half of the employer burden is overcome. The question of diligent supervision, however, depends on the circumstances of employment. So next is the sources of damage or the liability. For the article 1170, those who in performance of their obligations are guilty of fraud, negligence or delay, and those who in any manner contravene the tenor thereof are liable for damages. So first is the fraud. It is either incidental or casual fraud. Hala, mo naman yun.
So number 4, source of demand. Source of damage liability or Article 1170. So A, fraud. It is either incidental or casual fraud. Number 1, incidental fraud or the dulo incidente. Ang pasabot sa incidental kay murag kon siya kanang wala siya natuyo. For example, Carlo ordered 3 sacks of 160 rice from Bugas Trading. On that day of the delivery, Bugas Trading mixed 1 kilo of NFA rice to each sack. Bugas Trading committed an incident fraud against Carlo. Kung ako pasabot nga, dili siya, kibali morag dili siya, ano ba, kanang, wala siya gituyo. Next is casual fraud. For example, Biyahe Trading and Tour sold a promo plane ticket to Elsa amounting to 1,500 pesos, but Elsa does not have a budget for that. So she refused to buy it. The agency offered her an installment type of payment so she can really buy the ticket at a very cheap price. So they created a contract requiring Elsa to pay a down payment of 500 pesos and pay the remaining balance in 2 months. However, on the day of her flight, she found out that she was not actually booked on that flight and the ticket was actually fake. So, mo ni siya ang casual fraud, murag tinuyuan siya nga sala. So, kung sa kuha ni siya naitabo, pwede ko magkuan ka ng magreklamo sa ilaha. Next is negligence. One of the obligations of the obligor is to observe due diligence in the performance of his obligation. If the diligence required was not observed, there may be a liability. So there are two kinds of diligence. The first is the diligence of the good father of a family or the ordinary diligence. Second is at most diligence or extraordinary diligence. Next is delay. The delay referred herein is the legal delay. The general rule is that no demand, no delay. There are ways to demand the fulfillment of obligation. First is juridical demand. The creditor goes to court to fix the period within which the debtor will perform the obligations. Second, extrajuridical demand. The creditor writes a demand letter or demands orally. Next is the different kinds of damages. A. Actual or compensatory damage. B. Moral damages. C. Nominal damages. D. Temperate or moderate damages. E. Liquidated damages. F. Exemplary or corrective damages. So number 6, different kinds of obligation. In this section, we will only discuss the first 4 items as these are the usually transaction in this business. So first is the pure obligation. It is one in which is not subject to period or conditional and is demandable at once. So for example, Mario promised to give a chef hat to Alex. The obligation of Mario is immediately demandable in this case because his obligation is not subject to any condition or period. Next is conditional obligation. It is one where the obligation is subject to the condition. It is demandable upon the happening or non-happening of the condition. For example, Marie promised to give Maria a set of kitchen utensils once the latter finished her culinary course. This is a suspensive conditional obligation. If Maria was able to complete her culinary course, she could now demand from Marie the set of kitchen utensils. Next is obligation with a period. The happening or the arrival of the period gives rise to an obligation or extinguishment of it. For example, Maricel promised to give Myla a round-trip ticket for Singapore on June 15, 2020. So Myla may demand the ticket on June 15, 2020. Next is joint obligation. In this obligation, there are several debtors and one or more creditors, but each debtor is only liable for his share of the debt, and each of the creditors to his share is of the credit. It is always presumed that the obligation is joint. Next is solidary obligation. In this obligation, each of the debtors is liable for the entire obligation, and each of the creditors is entitled to the demand and satisfaction of the whole obligation from any of all of the debtors. Next is alternative obligation, and the last is facultative obligation.
Next is the Article 1305, which means a contract is a meeting of minds between two persons, whereby one binds himself with respect to the other, to give something or render some service. The contract is not actually the paper as defined above. It is the meeting of the minds. The instrument is where the contract was written. As a general rule, it is the evidence of the contract. So, for example, kanang mga demand letter or any kind of contract that will be used as an evidence or an instrument. Next is Article 1318. There is no contract unless the following requisites concur. Consent of contracting parties. Consent is manifested by the meeting of the offer and the acceptance of the thing and the cost, which are to constitute the contract. To create a valid contract, the meeting of the mind should be free, voluntary, willful, and with a reasonable understanding of the various obligations the parties assume for themselves. When consent is given through mistake, violence, intimidation, undue influence, or fraud, the contract is deemed voidable, meaning it is valid until annulled. So meaning if the requisites are not within the contract, then the contract may not be valid as clearly stated in this article. Next is object certain, which is the subject matter of the contract. The object of the contract may be things, rights, or service. Rules regarding to the object. The object of the contract must be within the commerce of man, which means that the object is capable of appropriation, and the object must be lawful. Next is services as an object should not be contrary to law, morals, good customs, public order, or public policy. And four, intransmissible rights cannot be object of the contract. Next is the cause of obligation, which is established. Cause or consideration is an essential requisite of a contract. It is the reason why the parties entered into a contract. Next is the formalities of contract. Contracts may be made orally or in writing as long as the three essential requisites are present. However, the rule above admits to certain exemptions, and these are first, when the law itself requires that they may be in some particular form, like writing, to make otherwise valid and enforceable, which is the so-called solemn contracts. Like for an instance, in the donation of immovable property, Article 749 requires that the deed of donation must be in a public instrument, meaning it should be written and notarized to make the donation valid. Another one is that the donation of movables worth more than 5,000 pesos must be in writing, or otherwise it shall be void. In a contract of partnership, if one of the partners contributes an immovable property, the contract must be in a public instrument, or otherwise it also be void. When selling a piece of land made through an agent, the authority of agent must be in writing, as what I've said above, that it shall also be void. Next is when the law requires to prove by some writing, as stated in a memorandum of its terms, as in those covered by the statute of, of frauds and Article 1403 of the Civil Code, their existence not be provable by mere oral testimony unless wholly or partly executed. These contracts are exceptional in requiring writing embodying the terms thereof for their enforceability by action in the court. Next topic will be the stages of contract. So any types of contract undergo stages. If the contract is written, the involved parties may use their vernacular language or any dialect can be used in making a contract, and as long as both parties understand the same. Generally, these are the stages of making a contract. First is the negotiation stage or the generation stage. In this stage, the parties will bargain or negotiate as to the terms and conditions. They do not agree yet on this stage. Hence, there is no meeting of minds yet. It begins with the prospective contracting parties manifest their interest in the contract, and it ends as the moment of agreement to the parties. Second stages of contract is the perfection or birth of the contract. It is here where parties agree upon the essential elements of the contract. After negotiation of the terms and conditions, the parties will now decide whether to accept it or not. Once it approved, then a contract is made. Since there is already a meeting of the minds, it, it is on this stage that the contract is perfected, and therefore both parties must comply. Third is the consummation or termination. When when the parties fulfill their obligations, the contract will end or will be terminated. Like for an instance, Alice met the event and catering coordinator of Wonderland Hotel to inquire about a venue for her debut. The coordinator presented a proposed quotation worth of 50,000 pesos, inclusive of the function hall and foods. Alice asked for a 20% discount, but the coordinator can only give 10%. So, was there already a contract made? So, di ba wala? So, since both parties are still in the negotiation or bargaining stage, so there still no meeting on the mind. Supposedly, Alice agreed to the 10% offer and consented all the terms and conditions. So then there is already a contract. So in that stage, the contract is already perfected. So nainahitabo nga contract. After paying the full amount and obligations were done and fulfilled on the said date by both parties, then the contract is terminated, and this is the consummation stage. So that will be the consummation stage. So next we will be discussing the characteristics of the contract, and the first characteristic is the mutuality of the contract. The validity, performance, or the compliance cannot be left to the will of only one of the parties. The ultimate purpose of the mutually principle is to nullify a contract containing a condition that makes its fulfillment or pre-termination dependent exclusively upon the uncontrolled will of one of the contracting parties. So next is the autonomy of the contract. The contracting parties may establish such stipulations, clauses, terms, and conditions as they may deem convenient, provided they are contrary to law, morals, good customs, public order, or public policy. Next is the obligatory force. So from the moment the parties perfected a contract, they are bound to the fulfillment of what has been expressly stipulated and to all the consequences which, according to the nature, may be in keeping with good faith, usage, and law. When the parties failed to fulfill the established terms and conditions of a perfected contract, a cause of action for breach of contract will arise. So next is for the relativity of contract. This means that the contract entered into by the party is binding only between them, their heirs and assigns, except in the case where the rights and obligations arising from the contract are not transmissible by their nature, or by stipulation, or by the provision of law. The heir is not liable beyond the value of the property he received from the decedent. Next is the defective contracts and their effects. Rescissible contracts. A contract that is rescissible is a valid contract that has all the essential requisites of contract. But because of the injury or damage caused to either of the parties therein or for the third person are considered defective and thus may be rescinded. Once the contract is cancelled, it is terminated and the parties will return to their original position as if there was no entered into. Or if the property or the object of the contract has been deposed, the value thereof shall be returned. So the following contracts are rescissible. First is those that are entered into by guardians whenever the wards whom they represent suffer lesion by more than 1/4 of the value of the things which are object. Second is those agreed upon in the representation of absentees if the latter suffer the lesion stated in the preceding number. Third, those undertaken in the fraud of creditors when the latter cannot any other manner collect the claims due to them. Fourth is those which refer to the things under litigation of they have been entered into by defendant without the knowledge and approval of the litigants or competent judicial authority. Last is all other contracts specially declared by law to be subject to rescission. The voidable contract are contracts that are valid until annulled. The Article 1390, the following contracts are voidable or annullable, even though there may have been no damage to the contracting parties. First is those where one of the parties is incapable of giving consent to contract. Second is those where the consent is vegetated by mistake, violence, intimidation, undue influence, or fraud. The contracts mentioned above are binding unless they have annulled by a proper action in the court. So next is the unenforceable contract. This contract is cannot be enforced by unless ratified due to any following reasons. First, the contract was entered into the name of another person by one who has not been given authority or legal representation or who has the acted beyond his powers. Second is the contract did not comply with the statute of frauds. In, for some instruction must be in writing to effect its in, enforceability, such as the sales of property, sales of goods, or the things if the price is not less than 500 pesos and an agreement to lease for more than 1 year. So if the contracts are not in writing, the other party may not sue the one who violated it before the court. So both parties are incapable of giving consent. Next is void and inexistent contract. It is equivalent to nothing and is absolutely wanting in several effects. It cannot be validated either by ratification or prescription. Although a void contract has any of its terms have been performed, an action to declare its existence is necessary to allow restitution of what has been given under this stage. So that would be all. Thank you for
So that's all for today. Thank you, ma'am.